All right. Well, let's go ahead and get started. It's a couple minutes after 11, and just want to make sure that we keep on time for everybody. We've got, it looks like about 100 people in the webinar at this point, or dialed in by phone. So good morning, and thanks for taking the time out of your day to join. First, just sort of the technology information. Because of the large number of participants in the meeting today, everyone is muted, and we would request that you could submit questions via the Q&A section of the Zoom app. So under Zoom, you can go and submit some questions there. We also have some questions that were submitted as individuals registered, so we'll weave those into the presentation as appropriate as we're going through the various slides that Adam has graciously put together. So, my name's Greg Hobson. I'm a partner and senior financial advisor at Greenspring Advisors. We provide retirement plan consulting to over 100 plans, and before the crisis, it was more than $4 billion in assets. That number has come down, obviously, based on the market's performance here in the last couple of months, weeks. So again, we're really happy that you joined us today. Most importantly, happy and hope that you, your loved ones, and your employees are staying safe and healthy through this. We know you have a lot of organizational challenges to work through during this time. This is not the only thing that you have to worry about is employee benefit plans. But there are so many critical decisions that you're going to need to make about managing your business and your employee benefit plans. And we hope that today's presentation and what Adam and I have kind of walked through the last few days here, we think this is going to provide a lot of insight to you to best help your organization and your employees come out of this pandemic as best as possible on the other side. So I'm going to basically turn it over to Adam here, and if you don't know, Adam is I'm really happy to MC this with him. He's one of our go-to ERISA attorneys. So he's an employee benefits and executive compensation attorney at Smith & Downey. He's also an adjunct professor at the University of Baltimore School of Law. So Adam, welcome, and I will turn it over to you.
Thank you, Greg. I appreciate the opportunity to be here. Can you hear me okay?
Yes.
Perfect. So I see already some names popping up in the questions that I know that I have the great privilege to work with, and I appreciate the opportunity to present with you, Greg, and all of Greenspring. Obviously, anybody on the phone probably works with you or potentially is considering working with you. And I just want to say I appreciate you guys pulling this together. For everybody on the phone, Greg called me last week and just said, hey, look, we're getting a bunch of questions. A lot of our employers need help, and they're thinking about different things, and they're hearing all these things that were passed by Congress. We're just trying to perhaps just pull up on a quick call, and let's do it as soon as possible. And let's just try to share some ideas, different things coming from Smith & Downey and from Greenspring's perspective. So I think for everybody on the call, it's a great pleasure to work with Greenspring, for you guys to be so proactive and thinking about the ways that we can answer questions. I told Greg our general approach here is that we have this great fortune to work with so many employers who have been calling us up over the past 2 weeks and really trying to think about how to help employees. Obviously, there are hard decisions that have to be made. This is a time of crisis. We're obviously hoping that we'll revert to a more normal time soon enough. But the general idea here is that we're so blessed to see some of these employers calling us and having such good hearts. This new term furlough, I knew what a furlough was before, but occasionally we come across these moments where you hear the word so many times over a period of 2 weeks, it becomes kind of word of the year. And so I'm thinking that everybody's kind of contemplating this idea of how to keep employees around, how to try to weather this storm, and it's really encouraging to hear all the employers think that, then again, at the same time, you do have Congress acting. I think anybody who's ever heard me speak before, I criticize Congress a lot of times, being somewhat satirical, that they're such a dysfunctional body. I think times like this do cause you to reflect and think that it was great that they passed the CARES Act last week, the Families First the week before. They are working as quickly as possible, and we're all fortunate to live in a country that our government can kind of pull together so quickly and offer such financial assistance for a lot of people. So hopefully you don't need it, but it's out there. Today's presentation is going to really focus on benefits. As Greg works with a lot of you on the retirement plans, I tend to work with a lot of you on retirement plans, health and welfare plans, and executive compensation. So Greg asked me, hey, I know Greenspring's just more focused on retirement plans and some non-qualified plans, but why don't you go ahead and cover some of the health and welfare too, because we'll have some of those people on the call. And I say gladly, that's what we're doing. There are other aspects of the CARES Act that will help small businesses, the different paycheck aspects. We would be happy to talk with you about those things. It's not really in our wheelhouse, but one of the things that we're seeing is that employers are in need. They're looking for how to get money. There are certain buckets of money you can probably access if you're under 500 employees. And if we can help you out in any way, try to find those buckets of money to ensure that you get them. There's a finite amount of money available. We'll try to direct you to the appropriate resources and willing to brainstorm with you to try to make sure that you're doing all you can to take advantage of those opportunities. So with that, Greg, why don't we flip to the next slide? Everybody, those are the disclaimers, of course. This is, for me talking, I tend to talk a lot about everything, and I'm not one of those lawyers who's afraid to give an answer. But surely understand if there's a question that these are general answers and general advice, not really particularized to individual situations. And despite the fact that I try to tell my wife that I'm always right all the time, I'm not always right all the time. So if you hear anything that sounds peculiar or might run contrary to advice that you get in other aspects, feel free to give me a call. I'll probably be the first one to say, oh, you know what, I misspoke or something along those lines. So, and Greg, obviously feel free. I have no pride of ownership. Jump in and say, Adam, I thought I heard this or I thought something different. And Greg and I are going to continue that conversation.
Certainly will. Certainly will.
Perfect. So we'll start on the retirement aspects. There's probably three big things really here, potentially four if you sponsor a single employer defined benefit plan. These are kind of my notes and string of consciousness. Greg, I think the slide popped off. Okay, perfect. And so sections, I took the code sections right out of the CARES Act and then started kind of giving my thoughts and takeaways from each of the provisions in the CARES Act, and that's basically the way I'm going to run through the retirement section and the health and welfare section. There are parts on the next slide and then a few slides down from the health and welfare where we just brainstorm through questions and think about everyday life events. But this is directly from the statute. These Section 2202 is both a distribution section and a plan loan section. The distributions, there's significant upside in this distribution. It's allowing coronavirus-related distributions to be granted for up to $100,000 from somebody's 401k plan, and it exempts that distribution from the 10% penalty. There's some really cool kind of features about this. It's one, it exempts it from the 10% penalty that might apply if somebody's under 59 and a half. Two, it's not going to be subject to withholding. It's also not eligible for rollover, for a tax qualified rollover to a different plan or to an IRA, but it's also not subject to withholding. So if somebody needs $100,000, they could take $100,000, no withholding, and then they have to recognize it in income over a 3-year period. Okay, so basically it sets up, there's some nuanced rules under the Internal Revenue Code Section 408 that deal with how you recognize the income during this 3-year period. And then the other thing that's cool about this is that they can also repay a portion of the distribution amount, all or a portion of, back to the plan or any plan that accepts rollover contributions within a 3-year period. So there's obviously some little nuances that might take place here as you're working with participants. Somebody takes the income into account this year, say it's $60,000. I assume when the legislation says it will be taken into account over a 3-year period, it's ratably. So I assume maybe you take $20,000 in income this year, $20,000 next year, and $20,000 the third year. And my assumption is that if you repay those amounts that you already took into account under taxes or in income taxes, that the individual participant will be able to deduct those amounts in a later year when they're recontributed back to the plan. There's no exact guidance on this. We're going to get some IRS guidance forthcoming, I'm sure, but that's just my best guess on kind of how those logistics shake out. But for right now, for purposes of plan administrators, the plan administrators will take this and they'll distribute it and no withholding. The coronavirus or coronavirus-related distributions are a specific definition in the CARES Act. And it's an individual who's diagnosed with the virus or disease by a test approved by the CDC, whose spouse or dependent is diagnosed with such virus or disease under such test, or who experiences adverse financial consequences as a result of being quarantined, being furloughed, or laid off, or having work hours reduced due to such virus or disease. And they're being unable to work due to lack of child care due to such virus, closing or reducing of hours of a business owned and operated by the individual due to such virus, or other factors as determined by the secretary. So that's the definition coming directly out of the statute. It's basically, again, for slides purposes, I just put it shorthand and put coronavirus-related distributions, but you should be hearing from your record keepers shortly on this distribution. And I will note, today's the 31st. If anybody on the call is with Fidelity, I believe Fidelity's been sending out mail-ins indicating that they are going to work based on negative consent, which is to say that they are going to implement these distributions, which are voluntary. They're going to implement the distributions unless a plan sponsor tells them otherwise. So if you're
Adam, that is correct. I know that Fidelity has done that. Some other record keepers, everybody's taken a little bit of a different tack. So it's really important as a fiduciary to your plan, if you're on the committee, human resources professional, that you're keeping a very close eye on notifications that you're receiving from your record keeper or administrator, because they are all handling it a little bit differently. But I know in your instance, Fidelity did say that they were going to have a negative consent, which I think is the tack that a lot of record keepers will be taking here. And that negative consent for Fidelity goes into effect tomorrow.
Perfect. Thanks, Greg. And so, yeah, I think that's just really important. Again, you'll notice I'm going to say a few things. There's a general human instinct. Obviously, right now we're all pulling together. We're all rooting for the best interest. I tend to have to, as a professional matter, think months ahead and think about potential risk of situations. And what should be happening here is you shouldn't just take Fidelity's word for it. You should make sure you take a look at make sure you take a look at what Fidelity is sending you and make sure you understand it, and make sure you document the decision as to when your agreement that the coronavirus distributions are going to come into effect, say April 1st, because I think there's always an available possibility for somebody to say that, allowing participants this money at the lowest point in the market to take this money out when they have no feasible means to repay it. Somebody could always be asserting different allegations. Now, of course, that's just a small little speck of risk compared to the greater good of allowing these distributions. And so I do think most plan sponsors are going to think about this, be prudent, and introduce this concept into their plan so people have some relief.
And Adam, my understanding that those are to qualify for the corona-related distributions and plan loans is a self-certification. Is that correct?
Yeah, so with respect to the third prong that I mentioned, with the adverse financial consequences as a result of those being quarantined, the administrator of a plan can rely on the self-certification from an individual, so that provides some protection for the plan administrator and makes it a lot easier. So unlike other hardship type of things where you might have to do a deeper dive, particularly before the Secure Act passage at the end of last year, this is a little bit easier, so you can accept that self-certification. And so staying on the same theme, because it's the same section, the plan loan takeaways, the plan loans are now increased limits for these for individuals impacted by the COVID-19 and or their spouse in the same definition. And their loans will be increased, the plan limits, to $100,000 or 100% of their vested account. That's up from $50,000 and the lesser of $50,000 and 50% of a vested account. So again, a good opening for participants to have a little bit easier relief. There's another provision in there that suspends loan repayments for 1 year if the loan repayments are due in 2020, and then it'll be re-amortized when you start up again. And if it's a 5-year period that you typically have to repay your loan, you'll be expended out for that 1 year period that it was the loan repayments were suspended. And the initiation, so the outstanding loan repayments are for any repayments due in 2020. The loan amounts, the loan limits increase up to $100,000, 100%. That's for any loans initiated within 180 days of the enactment, which I believe was the 20. Greg, what was the date of that? 29th, I think, or 28th was the date Trump signed it. So it would be 6 months or 180 days from that point.
Yeah, whatever Friday's date was.
Yeah, that's right, 27th. So those are the big ones. The next big one is a waiver of the RMDs for the 2020 calendar years for all DC plans. This is a defined contribution plans. It will have no impact on defined benefit plans. There's been, the policy rationale surely is this one obviously runs a little bit in the face of the other two. The other two are focused on getting money out of the plan. This one's focused on keeping money in the plan. And you can kind of read between the lines and see that Congress limited this to defined contribution plans because they didn't want to force people out of their plans at the lowest point in the market if they didn't have to go out of their plans. So they're basically waiving the RMDs for the 2020 calendar year, and they'll pick back up in the 2021 calendar year. So that's a good relief for anybody with money that would have been forced out. These individuals are the people who reached 70 and a half during 2019 and would otherwise be taking an April RMD payment, and so they can push that out.
Adam, we had a question as part of the registration where someone had asked about individuals that have, maybe taken their RMD for 2020 already. That they've seen some things where you can actually take that money and then roll it back into an IRA if you already took it out. Is that something that you've heard as well, and maybe how that works?
Yeah, so I was looking through I think that's right. Greg and I actually talked about this yesterday. I didn't see it immediately in the statute, but I think the interplay with 408, what it's basically saying is that if you get it back into an individual retirement plan, then the individual retirement plan can take advantage of these rules. Because I was somewhat skeptical at first because the way the statute sets up is it says a qualified DC plan under 401A, it says a governmental plan, and then it says an individual retirement plan. And so I think the idea is that if these IRA custodians are going to let that money back in, then these rules will all of a sudden apply to those individual retirement plans, and the 2020 distribution wouldn't occur. So if I was an individual, that's what I would be doing. If I took it last month and I had the ability that some Fidelity IRA or some other IRA would accept it back in, then I would put it back in and try to take advantage of that rule. I will caveat that I don't think it's perfectly clear, but I have seen some respected people start making that statement. So I'm definitely kind of coming around onto that being the case. Now, keep in mind, this one's a bit peculiar with some of my plan sponsors. The first two are clearly optional. You can introduce these distributions or the plan loans if you want to. This one is also seemingly optional, which is to say that if you're a plan and you're set to distribute money out this month, you don't have to delay the distribution. It's a voluntary exercise. The questions being is if you distribute it out, how do you code it? Do you code it as an RMD? Or not. And I think the answer would be, based on kind of some of this other feedback coming in, is that perhaps you're not coded in as an RMD. Your plan can kick people out as they would, because that would be a plan feature and you're choosing not to adopt this change. but you would code it as a non-RMD. Again, I suspect most plan sponsors are going to adopt this change. It's been mostly large employers who are going through this theoretical exercise of whether they have to adopt it or not. But just so everybody knows, these aren't mandated changes. The last two things on this slide are the DOL granted authority to waive deadlines for a health emergency, or DOL was granted authority, my apologies. That's just Congress obviously helping out and foreseeing into the future that the Department of Labor might, say, delay or waive a deadline for the Form 5500. So that's useful, and we'll alert you as soon as the Department of Labor takes that action, if they do. And then lastly, this is important for anybody for a single employer defined benefit plan. There's certain rules that require funding and minimum contributions to those plans. This statute went ahead and waived that minimum contribution that would otherwise be due under those rules for the 2020 year.
Hey, Adam, just two quick things. We have Tina had asked on the chat box here, if your TPA does not handle your loans, will you, as the employer and sponsor of the plan, have to get documentation that the participant qualifies to take the loan or distribution? I guess that's where we go with the self-certification. Is that correct?
Well, you would get the self-certification for the third point, but I think fundamentally the question that Tina asked is perfect, because people often forget you don't have to do what your TPA does, or you don't have to completely rely on your TPA. You're allowed to do whatever you want to do as a plan sponsor, obviously subject to operational logistics, but it is your plan. You are the gatekeeper. You're the named fiduciary. So basically the answer to Tina's question is yes, you would have to do whatever the requirements require of you, including obtaining that self-certification and kind of setting the terms of the loan. If you don't already have loans, you got to set up some type of procedures and policies. Presumably the way the two loan provisions work out is that you can take the loan under the, say, up to $100,000 on the limit if you're one of these COVID-19 affected individuals, and then you can also immediately delay any repayments that are due this year for 1 year. So you're in essence taking a 6-year loan under those provisions. And so for people that Tina's referencing, you want to make sure that you're setting up the appropriate policies and procedures to be able to implement and administer a loan program.
Another question just came in. How many loans can an employee take under this provision?
There's no limit under the Internal Revenue Code. It's just monetary limits, so 50% or 50,000, and then obviously now 100,000 or 100%. You can take as many loans. Most loan policies limit people to 2 loans, either 2 general purpose loans or a general purpose and a primary residence loan. And so basically you just want to make sure you're not violating your loan policy, but you can amend your loan policy to allow more. It's just administratively most people choose to do 2, just so long as you don't violate the monetary limits.
Yeah, we actually have a lot of plan sponsors across, I know, my book of business and other advisors here at Greenspring that work with plan sponsors that the limit is normally 1. Does this, sort of, if you opt for this type of loan or loan, does that, you have to now amend the plan to allow for 2 loans if somebody already has 1 outstanding loan to be able to get a coronavirus related loan?
Well, you bring up a great point, Greg. If your plan says 1 loan, you have to make sure, undoubtedly, do not violate the terms of your plan, because that will be a problem. So make sure you amend your plan. The plan should probably just say you can offer loans and then defer out to your loan policy on the administrative semantics. It probably just says, hey, you can take loans, follow the IRS guidelines or IRS rules under Internal Revenue Code 72, and then the loan policy will take care of all the little nuance. It's much easier to amend a loan policy, and it's much easier to say, okay, if you do grant an additional loan, we can come back and take care of your loan policy later. You just want to make sure that you're thinking about it and trying to stay as in line with it as possible. So, the prime example is if somebody already has 2 loans and they're trying to take a third one, and they do have room within those monetary limits to take advantage of this, it would seem perfectly reasonable to me to amend and allow 3 loans to allow for this. But of course, that's a plan sponsor decision.
Yeah, and there have been a couple of questions that have come through. I think you answered a couple of those. But essentially, the the last question that came through from Stephen is basically that if it's the spouse that's impacted, you can apply for that, and that is under the statute that you had mentioned, that it is yourself or a spouse or one cared for, correct?
Yeah, I'm going to pick on Stephen for a second. I'm sure he won't mind. It's not the spouse of someone that's able to take the loan, but obviously a participant can take a loan on, if their spouse is impacted, and I assume that's what Stephen meant. So yeah, that's the case. Of course, ex-spouse and it's an alternate payee and they have an account under the plan and they're allowed to take loans, they can do that too. But
all right. And I have one other question on this page, and I know we're already at 11:27 and we're through slide 1 of about 5 that you have. So one last question on this. This came up from another advisor on our team, one of our other partners at Greenspring, and their plan sponsor was walking through this with a record keeper, and that essentially the tax treatment and extended repayment periods for employees, are there potential risks to add the loan rather than just having the, offering the coronavirus-related distributions, because you can actually repay those over a period of time? Does it make sense just to have those and not have increased plan loans, because then obviously there could be some disadvantageous if somebody takes a loan and then they're laid off in 3 months, then that loan becomes immediately due. Wouldn't it almost be better for that participant to provide for just to use the distribution so that they don't potentially run in that situation down the road? And should employers consider that as a risk?
Yeah, I think that's I don't think employers should consider it a risk. I think basically offering both of these options available and allowing the employee to choose, or just sticking with the CRDs, the distributions up to $100,000. So basically, if you take a distribution, you got these cool little features where you can take it into account an income over 3 years as a participant. You can repay it as a rollover contribution. It seems to essentially be a 3-year loan with some income tax hits, because you obviously got to take some into account early. So I think somebody who knows they can repay it in the normal course might prefer a loan, but I think these 3-year repayment periods are pretty advantageous, and it sets up like a 3-year loan. It's a shorter time, so it's really just a matter of individual circumstances, I think, but both seem appealing, I think.
Okay. Devin has a question about RMDs. You want to take that, and I'll move on to the next slide.
Yeah, perfect. Looks like it says if a participant retires in 2020 and the plan waives RMDs for 2020, when is his required beginning date in light of the waiver? By what date would his account balance be valued as of the first RMD? So I think the retiring in 2020, in the normal course, their RMD would be owed by April 1st, 2021. Is when that RMD would become due. I think that's the typical RMD rules. So I think in that instance, it would be the 12/31/20, and it would be due by April 1st, and I don't think there's going to be a waiver. If somebody, I think somebody who had terminated in 2019 who was due their RMD by April 1st of this year is the one that's going to get an extra year extension. Right,
and then they're going to revalue that as of 12/31/2020. That's the whole purpose, is so that you're not basing it off of a market high in assets, that you're taking into account what's happened to the market. They did this in 2008 as well for RMDs.
Perfect. And so, Greg, let me make a suggestion. This other retirement considerations kind of blends in nicely with the other considerations at the end of the deck. Why don't we run through the health and welfare, unless you want to go through this slide. Do you want to run through the health and welfare tidbits real quick, and I can do those quick?
Yeah, let's go through that. Yep.
Perfect. So let me tell a kind of a quick story of where we've been at over the past 3 weeks on health and welfare. We got some early guidance as we started looking at the COVID-19. What had started happening was some different state insurance agencies started indicating that the insured plans in their states were not allowed to apply any cost sharing when it came to COVID-19 testing. And so plan sponsors who sponsored high deductible health plans, who also had HSA eligibility, were rightfully worried that without cost sharing that they would flunk their HSA eligibility, because a HSA, by its very nature, you're only allowed to make contributions to a health savings account if you have a high deductible plan, which means you have to essentially satisfy that deductible before things are starting to be waived unless it's preventive care. And so there was this kind of disconnect between the state insurance commissioners and the high deductible health plan rules. So early on, the IRS came out and said, hey, you won't flunk your high deductible HSA eligibility just by offering COVID-19 testing at no cost. So that was an early piece of guidance that was useful. It was limited to COVID-19, and the other HSA requirements were maintained. We'll talk about what the CARES Act did to that in a second. The Family First Corona Response Act was passed, I think, 2 weeks ago now, and it required group health plans and insurers to cover and not impose any cost-sharing requirements for COVID-19 testing. And then the HHS Frequently Asked Questions was passed on March 12th, which redefined essential health benefits. Now, large group insured products and self-funded health plans aren't required to offer essential health benefits under the plan, but if they do, they can apply lifetime limits or anything along those lines. So obviously those FAQs were really just updating for that definition of health benefits to include the typical things, coverage and diagnosis and treatment of COVID-19. Greg, why don't you move on to the CARES Act, just so we can kind of get to the meat and potatoes of that. So the 3201 of the CARES Act, which was passed last week, made a technical correction to further clarify the definition of what's included in the mandate for group health plans to cover first dollar coverage. And the important part of this was it was expanded to include certain tests outside of the FDA approval process. This was vital because there were certain state-developed programs and consumer-developed programs that were being set up, and the CARES Act wanted to essentially make sure that those tests were included at first dollar coverage. This probably is a pretty low impact because your TPA, if you're a self-funded plan, or your insurance company is probably already into that or in motion based on the Family First Act. The second one was important. They wanted to minimize price gouging for these COVID-19 testing, so they either required to pay the specified contractual rate, or they required a provider to post the rate that was going to be charged and make sure that they stuck to it, and obviously, you know, for good policy reasons on the price gouging. The Section 3203, this might be important for a lot of your self-funded health plans. What they indicated was that the vaccine needs to be covered at no cost and defined as preventive care within 15 days of the vaccine getting the appropriate designation. And the reason this could be important is because the plan has to cover it if it's considered preventive care, and the cost of the vaccine is currently unknown. So most of the time when these designations are approved, the group health plan is not required to cover it as preventive care until the first of the year after the designation is achieved. But under this one, it's going to be within 15 days. So it's going to be very quick, and it could come with very hefty cost. We're obviously hoping not, but you know, that's a big drop in the window to make it preventive care within 15 days. Greg, would flip to the next slide, please. Yep. The HIPAA considerations I'll gloss over. Obviously, this is obviously trying to think of and clarify the extent of which protected health information can be disclosed. Obviously, a lot of people have been calling me up, employers, and saying, hey, can we tell all of our employees that Jane Doe has coronavirus and just so everybody's safe? That's typically, and they all start with, is it a violation of HIPAA? And it's not. An employer is not a covered entity. An employer is allowed to maintain their workforce. You do want to consider Americans with Disabilities Act and potentially the genetic information. It's GINA is the acronym for the statute. There are other considerations, but it's not a HIPAA thing because the employer itself is not the covered provider under the HIPAA rules. But this will apply to providers and health plans when HHS provides guidance. The telemedicine relief, this is very important, especially for large employers who are trying to take advantage of this. It establishes a safe harbor to use telehealth and other remote care services without adversely affecting the HSA and HD or high deductible health plan. And so this is the corollary of what the IRS did earlier this month or earlier in March. And this really says, hey, not just COVID-19, but any telehealth is not going to mess up your HSA eligibility if you want to provide these at no cost. So that's very good. It's not limited. There is a sunset on the provision, 12/31/2021 for calendar year plans, but it should very much help in the short term because we're all going to be struggling. There's a whole lot of things that are going to be problematic if you can't see in person. And then lastly, this is the last little tidbit, but it's very important. The Section 3702, what it did was it seemed to be focused on menstrual products and feminine products that were redefining under Section 223 to essentially be an allowable cost to deduct and define it as a health benefit. But what it actually did was it eliminated Section 106F of the Internal Revenue Code, which previously required that any over-the-counter products to be reimbursed under a group health plan or an HSA to be with a prescription unless it was insulin. By eliminating that provision, it basically allows over-the-counter products, so long as they are defined as medical care, to essentially be deducted and be offered and reimbursed on a tax-free basis. So that was a big change. I wonder whether they actually intended that or whether that was a slip-up in their provision. Because they seem to be focusing on one thing, and then the kind of consequence of that change is much broader for health plans. So if you're sponsoring a self-funded health plan or otherwise involved in administration, make sure you take notice of that change because it is going to be a big difference for your health plan costs. All right, Greg, why don't we move to the next slide? And I guess I threw this one in because the student loans. So your Section 127 of the Internal Revenue Code currently allows for educational assistance programs. This puts repayment of student loans that are made during the 2020 year as an additional component of an educational assistance program. It broadened the definition to include student loan repayments by the employer. Student loan repayments have been pending in front of Congress for 5 years, and they haven't seemingly been able to work out a way to make it an employee benefit. This seems to be, maybe a preview of what they should and could do, or they could do, and many people suspect that they're going to do anything, that this should be it, which is just to say if an employer makes your student loan repayments on your behalf, on an employee's behalf, they will be tax-free, and they can be made either directly to the employee or to the provider. Being a 127 plan, though, they are subject to non-discrimination rules. So if you want to take advantage of that by, creating some initiatives for your employees who might have student loans, it's something that you can do in 2020 on a tax-efficient basis. Okay, Greg, we'll jump to the next one. Okay, so Greg, this is where I can say we can kind of pull the other one back in, or we can go on this slide, whichever one you kind of prefer, but I'll let you kind of MC it and see if anybody has any interest on any of these.
All right. Well, because the healthcare side scares me, because that's where I can get myself into trouble of knowing a little bit and knowing enough to be dangerous, right? So, let's go with the retirement considerations first, and I really appreciate because this slide, when you put it together and we looked at it, it really encompassed a lot of the questions that I was getting as businesses and organizations are considering their options in this. I have some organizations where they're hiring like crazy because they need to, but I have other organizations where obviously they're in a completely different position and trying to figure out how to manage their workforce in a potentially declining revenue environment or an environment where they can't actually function as an organization. So, this first thing that you had mentioned about, the considerations about eliminating, fixed, whether it be a profit sharing or a matching contribution that's stated in the document, or even if it's discretionary, sort of what are the procedures that employers should think about as they're going through this they're looking at, well, do I delay it or how do I go about it?
Yeah, so I think just making sure you look at your plan document. Again, this is the risk perspective. The last thing you want is to be sued 6 months from now when everybody stops kind of viewing this as a pull together thing and starts thinking about different ways they were slighted. And I don't necessarily mean people. I mean some of the worst kinds of people, the plaintiffs' lawyers. I'm kidding. I like plaintiffs' lawyers, but we can all kind of understand that they may go looking for different areas to find non-compliance and different things, and especially if they can find 80 employees who all of a sudden had their safe harbor matching contributions turned off on April 1st, and they weren't given 30 days notice, the rules weren't complied with. That's going to start a lawsuit on behalf of 80 employees that could become expensive, and there is an attorney's fees shift in provision. So basically, you want to look at your plan document, see what your plan document says, and then you want to move over to, if you're a safe harbor plan, you want to move over to your safe harbor notice. If your safe harbor notice included a statement that the employer may reduce or suspend employer safe harbor matching contributions, you can do it in any event, even if you're not operating at an economic loss. But you still want to give the 30 days advance notice. The 30 days advance notice is very important to the IRS because they view these safe harbor allowances as if employees are planning based on this information. And if they receive the notice saying that there's going to be a match, they probably made deferral elections based on that information. So make sure you give the 30 days notice, and then you can basically discontinue it. Before you do that, though, you do want to talk to whoever tests your plans, because if you're going to flunk testing on the back end, which you're going to be required to do, you are going to be required to test the plan at the end of the year. You know, that could create more problems than it's worth. So you do want to get together with your TPA, think about testing considerations, talk with counsel about, you know, what your current documents say, what your communications are going to look like, and if you have to, obviously, you can eliminate the safe harbor contribution. If you don't have a safe harbor contribution, if you have a fixed contribution or some other type, you're much more likely to be able to discontinue it prospectively. The big rule, of course, is that you can't eliminate a contribution that has already been earned or the conditions have already been satisfied to achieve or receive it. So you just, again, want to look at your plan, think about your ability to essentially reduce this cost to the bottom line of the company, and then potentially pull the trigger after considering all those things.
Adam, one thing I did want to mention, I sat on a webinar yesterday from the American Retirement Association and the National Association of Plan Advisors. And one of the things that was mentioned by that organization is that they had sent a letter to the Treasury Department last week requesting specifically safe harbor relief for plan sponsors, so that they don't, have to make try to do something that's, certainly not potentially possible in 2020, but also allowing for that employer, while suspending that safe harbor contribution, to also pass testing as a safe harbor plan for 2020. So I don't know obviously that's something they've requested. Who knows what will come of that, but there are some, sort of lobbying organizations that are trying to work to help plan sponsors that are in this safe harbor type of environment. That was their intent, but obviously this is something well out of many employers, well out of anybody's control. So.
Yeah, and thinking outside the box a little bit, Greg, that's very, very helpful, and we're kind of thinking through these things right now. The Secure Act did provide a lot more relief for non-matching safe harbor plans, meaning that the plans that make a non-elective contribution. And one of the things that it did, and I'm sure everybody on the phone will forgive me for brainstorming out loud, but the non-elective contribution rules allowed a plan to adopt a safe harbor plan and make a non-elective contribution in the amount of 3% if the plan was adopted by December 1st, and 4% if it was adopted by the due date of their tax returns the following year. So meaning all the way through to your tax return with extensions, and you'd have to make a 4% contribution if it was after. So if it was after December 1st of the plan year, but before your tax returns, and you adopted that, you could make a 4% safe harbor contribution. So it's another consideration to think through for anybody who's struggling right now that could still be concerned with testing, but thinks cash flow will pick up at the end of the year, that perhaps they could discontinue the matching contribution, but somehow take advantage of those rules maybe later on this year by essentially making a non-elective contribution on behalf of all employees when cash flow is a little bit better. Again, it's a little bit of brainstorming just because what you said reminded me of some of those old rules. But clearly you can see how the IRS and regulatory guidance and legislative guidance is trying to make it more, make it easier for plan sponsors to kind of navigate through these rules. So perhaps there are options, and you should think about it with respect to your plan, talking to your advisors like Greenspring, and probably talking to legal counsel as well.
Right. I mean, you definitely, us legal counsel, like Smith and Downey, and also the record keeper, right? Thinking through how, because there's the operational component of how you're going to potentially, as a plan sponsor, be able to make those changes, on the fly, essentially. And the other big question that we're getting, and you would put this together again, the two things that we've been getting questions about at Greenspring are contributions, safe harbor, how do we potentially delay or stall if we need to, or if we need to already, and then the partial plan terminations. And as you laid out here, it's a facts and circumstances test, which is, creates some questions around, are you actually laid off or are you furloughed, and how does that play into whether or not that actually is a decrease of 20%? And then if you're rehired by the end of the year, does that factor in? So those are the questions that we're getting a lot, if you can shed some light on that partial plan termination rule.
Yeah, so I think the idea would be that this is drilling into this a little bit. I always think of partial terminations, and I think 20%, but it's important to remember that that's just kind of a presumption. It is based on a facts and circumstances test, and the revenue rule back in 2007 that really established that 20% test and kind of laid it forth. They didn't really consider the temporary layoffs that we're seeing. Again, furlough is a kind of a word that's all of a sudden being used all the time. So when you're considering laying people off for 2 to 8 weeks, perhaps, or maybe 12 weeks. And you're kind of trying to consider whether that constitutes a partial termination, I recommend you hold on the determination, and then you think about, if you're coming close to that number, even up to 15% or so, you think about the, characteristics of determinations, you think through the facts and circumstances, you apply it against your situation, you make determinations on whether people were truly terminated or whether there was an offer to come back to employment, and then make that determination maybe later this year. If you do make the determination that it was a partial plan termination, or that the IRS could come in and allege a partial plan termination, you're going to have to go back and vest all those people that perhaps forfeited money when they terminated and took distributions, because that's basically the consequence of a partial plan termination, is that you'll have to fully vest any unvested money. And it will just be for the folks that are affected. So anybody that terminated employment during that period, and they look at this collectively. So it could be a termination today of, say, 5% of the workforce, termination next month of 10%, and termination 6 months from now for another 10%. And IRS would say, hey, for this plan year, there was likely a partial termination because that adds up to 25%, very simplistically. But there might be a way that you could look at that and say, no, we were bringing people back. This wasn't really laying off 20%, and we can work through those factors and perhaps try to avoid that consequence.
Yeah, certainly an area where you want to get ERISA counsel involved in helping determine those types of things. And I would say, just as from an operational perspective, if you think you might run into those cases and you have a vesting schedule where you're not a safe harbor plan with 100% vesting, or is that if you have been using those vested or those forfeiture dollars to offset plan contributions or pay fees or whatever it might be, you might want to hold off on that if you're in danger of potentially going down that path. As some plan sponsors I know use those for fees, offsetting contributions. If you have or determine later on that you had a partial plan termination and all of a sudden you've used all those dollars. Now you got to put those dollars back in somehow to basically pay those people that may have taken distributions during that time, and they may have been coded as 40 or 60% vested, but they were actually in effect 100% vested. So just be mindful of if you're potentially going to run down that path of using those forfeiture dollars at this point in time. Obviously, something to certainly consider going forward. I do know that, as I mentioned, the American Retirement Association had sent a letter to the Treasury on March 24th, and that also included not just information about safe harbors, but also about potential changes to what deems a partial plan termination for the year 2020 based on coronavirus issues or COVID-19.
Perfect.
All right, so Adam, I know it's 11:52. This is set up for an hour, so I do want to try to be respectful of everybody's time. It looks like we can go past the hour, but I do want to make sure we get to everything. Real quickly on the temporary employees and then the fiduciary risk, and then we'll get to the other considerations.
Perfect. So the eligibility for temporary employees, just remember you can probably set out an eligibility criteria for temporary employees with the caveat that if they work 1,000 hours, they're going to have to be eligible. It's much like part-time workers. You can't kind of designate them as ineligible just based on that status because it's a service designation, but you can set them apart under certain rules and then let them come in if they work 1,000 hours. So that's one thing. Just make sure you're clear on that and you can understand the way you're operating your plan. Again, that's an employer involvement thing. Don't defer to your record keepers on that. Make sure you understand what your plan says and make sure your payroll departments understand exactly what the plan administrator has decided on that. Fiduciary risk, Greg, I'm going to just say that, most of the people on this call, if they're dealing with Greenspring, they're doing the right thing. Greenspring does a great job on fiduciary risk. We have a lot of mutual clients. I sit in on a lot of meetings with different advisors around town, and Greenspring's top-notch for taking minutes, for thinking about prudent decisions. But clearly, anytime the market tanks, the market does different things. The investment fiduciaries need to be thinking about how they manage that risk and how they decide whether they're holding investments, whether you need to do anything else, emergency sessions, what else is prudent. And again, I'll tell you, I think Greenspring's working through all those things. But even if you have other advisors, say Greenspring's not your advisor, or even if Greenspring is, if you're responsible for your plan and managing this amount of money, you should know what is happening and making sure it's being documented and appropriate decisions are being made. Because again, 6 to 12 months from now is when the time you'll get a call and you'll say, hey, why did you stay in the Dodge Cox fund when it was so clearly tanking and impacted so much by coronavirus? And obviously I'm picking Dodge Cox fund out of thin air. I have no idea whether it's a good investment performance or not. But just make sure you're documenting the decisions, especially in this volatile time. That's all.
I think that's probably the most important thing is you need to think about this as obviously these are, very challenging times from a market perspective. We've been through challenging times before from a market perspective. And that those decisions you need to think about in the long term, not in the short term. And as advisors, we're hopefully there to help you consult through that. Rely on the IPS to help guide those decisions. Think about if you're pulling a fund for or you're panicking over a particular fund because of poor performance for a quarter or a couple of quarters. That's not necessarily deemed to either A, be on the investment policy statement watch list, or B, eligible to be removed. So, thinking about those decisions in the long term, like we talk about, tell employees, make your investment decisions for the long term, not just, the next week or month based on where the market is. So, the last thing, the other benefit considerations, I did want to get back to this here for those individuals. We only have a couple more minutes till 12 o'clock and do want to be respectful of folks' time. So certainly if there is anything that we don't get to today, or that you didn't or need an answer to, certainly reach out to whoever it is that sent you the invitation, whether it was at Greenspring or elsewhere, or you saw it on LinkedIn. Reach out via that source, and we can try to help answer any specific questions that you have that we didn't get to today, or that you thought of after today's meeting. So, with that, Adam, if you want to kind of run through a couple of these things here.
Yep, and to anybody, feel free, if you see one of these 7 or 8 targets and you want me to speak more details, you can ping it in real quick. Just put the first word of the bullet point, and I can speak more on it. I think the first one is just the most important, and what we're getting a lot of questions with is that these folks are being furloughed, and the question is, hey, do we have to continue to cover them? There's a basic benefits eligibility provision here that suggests a lot of your plans might say that if somebody's terminated or they're not active at work, that they should end their benefits at potentially the end of the month in which they're not active at work. And the one thing I'm seeing on a lot of questions is that there's a severe disconnect between 3 things. The first is the stop-loss contract if you're a self-funded plan, or a fully insured insurance policy if you're a fully insured plan. So we'll call it the carrier's contract. The plan document eligibility provisions, the typical eligibility provisions that just say how people are eligible, and then the measurement periods for Affordable Care Act compliance for those applicable large employers that are relying on certain measurement periods, called the look-back measurement period for the Affordable Care Act compliance. And that generally says is, hey, for purposes of complying with the Affordable Care Act, you could either cover people on a month-to-month basis, or you can measure people over an entire year, say 2019, and then decide how to cover them for 2020 for purposes of complying with the Affordable Care Act employer mandate. And what those provisions often say, which a lot of employers rely on, is that you have to cover employees regardless of their hours for the entire stability period, meaning a lot of times it's often the plan year. So your plan might say, even though people aren't actively at work, that you have to continue to cover them for Affordable Care Act compliance through the entire year if they're still employed. Now, if you terminate them, it's easy. But if they're quote-unquote furloughed or on some kind of unpaid leave, you might still be required to cover them. Now, what I'm saying is that the plan might say that, but your stop-loss carrier contract might say something else. And I'm really concerned with the amount of medical costs that could be coming up, that maybe there's a disconnect between the plan measurement periods and your stop-loss contract. So what I'm encouraging everybody to do is obviously figure out what their plan document says, and then go to their stop-loss carrier and say, hey, we're putting these people on furlough for 8 weeks, 12 weeks, 16 weeks. Can I get written explicit consent that you're going to cover these folks, and to make sure you're carried? Because if there's a claim 2.5 months down the road for somebody who has brain surgery, God forbid, and it's $2.5 million, it's at that time that the stop-loss carrier is going to come back and not be so nice. They're going to say, our contract has an active at work requirement. That person wasn't actively at work. They were on this term called furlough, and you're choosing to keep them like they were employed, but they weren't, and they're not going to cover it, and it's going to hurt people. Greg, I do have a few more minutes if you want me to keep talking, but of course anybody who has a 12 o'clock obviously can jump. Do you want to just run till 12:05 or so?
Yeah, I think that's fine. I'll just say for the folks that do have to drop off, because I see, about 20 people have dropped off already, I'll just say thanks to all who joined and your questions via the chat box there. If you're interested in a copy of the presentation, please contact the person that invited you, and they can provide you a copy along with Greenspring's document covering the CARES Act on the retirement plan changes. Gets into some more specifics along with, the description of what is a covered employee for purposes of loans and hardships and that sort of thing. And be safe, healthy, help flatten the curve, thank a healthcare worker. And then one other quick thing, on Friday afternoon, and you'll be getting an email from Greenspring Advisors, we're going to be hosting a webinar for plans for companies that are really under 500 employees with a couple of other partners that we work with in the Baltimore community on small business loans and the opportunities that exist for small business employers. So keep an eye out for that. That should be really entertaining as well. And Adam, I'll let you kind of go through the rest. And for those of you that have to drop off, we totally understand. And certainly reach out to us if you have any questions about what was covered today. But I'll let Adam, if you want to go over the next couple minutes, and then we can officially wrap up.
Yeah, perfect. And I will say, Greg, that's a great thing you're doing on Friday, because the ability to get that money is drastically underserved right now, while everybody tries to figure out who actually has expertise on this unprecedented type of thing. So you pulling together resources again on Friday is terrific. So anybody that can join that, I think that's a great idea. So Missy, you had put in the change in dependent care FSA and the health FSA elections. Basically, the idea is the dependent care FSA elections for a lot of these change in circumstances will qualify. Typically, most of the time people have been reaching out to us. I had an email somewhere here where I'd answered a question, but we typically find that the dependent care FSA change in circumstances, because of the change in, say, somebody working from home or the daycare being shut, are going to qualify and allow you to change those elections. Again, subject to your own plan document and policies, but I think they will typically fit within the 125 rules on changing elections and 129. And then the health FSA elections aren't quite the same. It's a lot harder to kind of fit in to change a health election on those. I encourage you to check your policies, work with counsel to maybe see if certain scenarios fit in. But typically those answers are not as easy to come by. I lost my Zoom screen. Greg, can you still hear me?
I can hear you, but yes, definitely cannot see you at the moment.
Okay, perfect. Well, I'll just finish up. I think I recall I was actually relying on the screen for the thing. But the COBRA elections, also think through how you start COBRA. If you're putting people on furlough and they're changing their COBRA or health plan eligibility, there's a chance that could be a COBRA event. And if you're an employer that continues to cover that employee, that's all well and good. There are some considerations, as we were discussing earlier, but there's, you might keep them on that status for, say, 8 to 12 weeks. And if you don't start the COBRA immediately upon the COBRA event, it's not going to start your 18-month window that you have to offer COBRA. So you have to decide whether, when you reduce these hours, that would be a COBRA event. You can start the COBRA period, and you can still subsidize the employer premiums. But if you don't start it at that point, you're going to be on the hook to start it whenever that 8 to 12-week period ends, which will put you on the hook for a longer COBRA window. So again, just something that you're thinking through and considering. I think I have the privacy concerns. Everybody reach out to your employment counsel. I have a colleague, Doug Damaris, who has done a great job stewarding through those, but consider people's privacy issues when you're thinking about disclosures and different things. Again, it could be Americans with Disabilities Act impacts, GINA impacts, and I'm going to leave the rest out there. Greg, I'm going to turn it back to you, but everybody who's still on the line, again, best of luck to everybody. I will leave you with a small little joke that I always leave for the end of the presentation, not the beginning, because I'm afraid people will hang up on me. But I am a Patriots fan. My beloved Tom Brady left my Patriots, and you could tell we are in a crazy year when I consider that to be a minor event in 2020. So I hope we will return to normalcy soon. And when something like Tom Brady leaving the Patriots, hopefully that would be a much more material impact, but obviously it pales in comparison right now. So everybody stay healthy, and thanks for listening to me for this past hour.
Adam, thank you so much for taking the time out of your day to provide our clients and prospective clients and centers of influence with some great information about and boiling it down to its most simplistic form as we possibly can, while we're still learning about how this act is really going to be applied and utilized by companies and plan sponsors. So certainly appreciate your time. Again, thanks for all those who joined today and even stayed on for the extra 5 minutes. If you are interested in that copy of the presentation, just contact the person that invited you and we'll get that out. So be safe, healthy, and thank a healthcare worker out there for what they have already been through and what they will be going through in the future. But, we will get out of this at some point. point, and we'll look back and come out hopefully stronger in the end. And Tiffany, who just wrote "Go Pats," I'm going to have to not allow you to participate any longer in any presentations that we ever do. I'm not sure. I'm not familiar with who you are, Tiffany, but we will block you. Just kidding, obviously. Thanks for attending, and have a great week, and enjoy the time with your loved ones that you do have. All that new extra time that we have now been allotted that we didn't necessarily have before because we were too busy in our lives. So enjoy that. Have a great day, everybody. Thank you very much.